Good afternoon, everyone. Thank you so much for joining us for this presentation today. We're going to try and keep it short just because we know everybody's busy, but we wanted to go over just a few different things. So I'm Philip Bluestein with Rocky Mountain Wills and Trusts, and I want to welcome you to our presentation. I'm going to turn my video portion off so you can just focus on the actual presentation here, but I'm going to go ahead and take care of that, turn that off so that it won't be a distraction, but you'll be able to see the slides as I go along and we talk. So without further ado, I'm going to just remove myself from this right now, and you should still be able to hear me. So as we said, this talk is understanding different types of estate plans, or the importance of understanding different types of estate plans. And what we'd like to talk about is kind of just a general overview of these kinds of things. Some of you already may have some information, but as we said, this is Rocky Mountain Wills and Trusts, and we help people take care of their families and protect their assets by creating effective wills and trusts. So today, we'll start with what is estate planning. Well, estate planning is defined as arranging your affairs during your lifetime. And it really is during your lifetime. You don't want to try to do estate planning after you're gone. It can be done, and we'll talk about what happens if you don't have anything in place and how that, but it's not really a plan, it's more of a consequence if we don't do it during our lifetime. So it really is making some plans, making some decisions during our lifetime. So essentially, there are several different types of estate planning. We can start out by, we can do nothing. We can use joint tenancy, beneficiary designations. We can use transfer on death clauses and things like that. We can also do a will-centered estate plan, or we can do a trust-centered estate plan. And those are the things we're going to be talking about today, what the different ones are, what they mean, and how they interact or how they fit into an actual estate plan. So, first one, doing nothing. A little play on this. Basically we are changing this a little bit, saying, okay, this is a say nothing, see nothing, hear nothing, as opposed to the traditional reference to it. But that's basically doing nothing, and is referred to as dying intestate or intestacy. That's the language that is used in that. So if we don't do anything, I have a diagram here. You don't have to take it all in, but basically, as you can see, everything flows into the probate court. Everything goes through the probate court. When we don't have a will or any other designations, what happens is the probate court will decide, according to Colorado law, who gets what, how things happen, etc. So it's going to decide who the heirs are. It will definitely be probate costs. It's probably going to be even more expensive because there isn't even a will to look at. So there's some additional costs. An attorney has to be hired. So there can be many thousands of dollars, thousands and thousands, tens of thousands, depending on the size of the estate and the complexity of things involved. In addition, there may be taxes and various things like that. So it's certainly not something that we recommend for people, but it is, the state has this kind of backup provision for you. Essentially, they're going to decide who gets what. It does not protect for a lot of other things, though. It doesn't. It's not really going to necessarily carry out your wishes, particularly if you have certain desires of how you want things to be done, such as certain people getting certain amounts of money, or certain things that you own or possess, family heirlooms, things like that. It's also not going to basically decisions about minor children. Those kinds of things are going to be done, again, by the probate court, not necessarily according to your wishes or your desires. So the probate court's going to have to appoint a guardian. They're going to have to appoint a conservator, which is the person who takes care of the money for minor children, or maybe a disabled adult who does not have capacity to take care of it for themselves. So there's a whole host of things that can go on, can really raise costs, can cause all kinds of complexities. It also can cause a lot of hardship to a certain extent, or a lot of issues within the family over who ought to get what. There's really no guiding principle there, at least based on what you want. It's going to, again, all be determined by the probate court according to Colorado law. So things are just kind of left hanging in those senses. The next one we talked about is using joint tenancy, beneficiary designations, transfer on death, etc. These are actually quite common as well. People will want to do these things. However, they still leave a lot of things up to chance or various things. So this would be where somebody might take their home and they might have it in the name. Often we'll have joint tenancy for a residence. It'll be the name of the spouse. That's fine. That's very common. Sometimes they'll say, okay, I'm going to have a joint tenancy with my child because my child or my children are going to inherit the house, and I want to take care of it that way. So same with beneficiary designations. There might be a beneficiary designation or a transfer on death, not necessarily with a house, but could be with investment accounts, bank accounts, those kinds of things. So one of the issues there, though, is when with a joint tenancy, you actually are transferring the asset to somebody. So there could be some tax implications on that transfer, even if you're only transferring part of it. There can also be issues with if that person has creditors, for example, if they have debts or something like that, or they get into a car accident and they get sued or various things like that. Or it could even be a divorce issue comes up. Well, is that part of the marital estate for your child or children that you put on the joint tenancy or created a joint tenancy for? So there's some issues there where the assets are really not protected. It also doesn't deal with all those assets which literally aren't mentioned by that. So other things, if you don't cover anything that's not put into a joint tenancy, everything that doesn't have a specific beneficiary designation or other types of things, those are subject to a variety of challenges by the potential heirs. In addition, and this is going back to the slide, you can kind of see how we have it with the joint tenancy or various things. There could still be probate costs, probably because not everything is going to pass through that. The heirs or your beneficiaries, the ones that are not dealt with in that joint tenancy or those particular designations, for the assets that are not dealt with that, those are going to pass again. If you don't have a will, they're going to pass through the probate court, and the probate court's going to decide who gets what. You can also see, I don't know if over on the right side of the slide, you can see that we are looking at, basically it shows, you can see the X's out, so there are various ones. So you can divide your assets out and say, well, this person gets the house, this person gets that, this person gets this investment account. But the problem becomes often that those are not going to balance out very well. So now you might have unhappy heirs. And we all think, okay, there won't be a problem. I'm just going to do it this way. But unfortunately, people can get very upset, or certain issues come up, old rivalries, various things like that. And when when you're choosing not to do things equally, it can cause more problems. That's not saying that it has to be equal, but what you're doing though is asking for a lot of potential strife, because if your intent is to pretty much divide things equally, it is very hard to do. You have to be constantly balancing things. What happens if you've done that with your bank accounts, but now when you pass away, those bank accounts, certain bank accounts that you left for one individual or another individual have been depleted because of various other expenses prior to your death. So those can be very complicated and really challenging ways to really wrap things up in a smooth and easy way. So we generally don't recommend that as a primary way of planning your estate. It can be part of other estate plans, but again, in most cases, people are wanting to balance things. They don't want to take on that risk of exposing assets and various things as well. So the next one, and this is probably the most common for people, is a will-centered estate plan. I will say, however, while this is in many cases the most common, that is actually changing. It's not quite as common. There are more common methods now, but also when we look at the estimates of it, that over 50% of the population right now dies without a will or some kind of estate plan other than what is provided by the state through Colorado law or various things. So this, however, though, for people who actually do an estate plan, this has traditionally been the way to go. This is what people have done for many, many years. It is the most common, as we said. So if we look at the slide here. Again, don't get drawn too much into the slide, but it's pretty straightforward. You can see when you have a will, basically all your assets will be disposed of by the will, and the will is going to kind of explain how everything is laid out. There will be probate costs involved. It's going to go through probate when you do that. You're going to name the beneficiaries in your will, so who gets what and how much. They may be equal the way you divide it up, or it might not be. You can do that however you want. There may be various tax consequences, just depending on the size of your estate or depending on how various assets are held. There's nothing wrong with a will-based plan. Certainly, like I said, it has been around for a very long time. But it will go through probate, so certain costs will be incurred. A lot of people don't want to have their remaining assets diminished by having probate costs come out of that. And when I say probate costs, I don't just mean the actual court fees and various things like that, but there is also the attorney's fees, which can be many thousands of dollars depending on the size of the estate again, and depending on the complexity of how assets are held. There may be assets in other states. So for example, here in Colorado, where we are, a lot of people, they may own property here in Colorado. Certainly our Colorado residents may own real estate here, but there are people from around the country who maybe only live here part-time, or maybe they have that vacation home. And certainly residents in Colorado may have real estate in other states or things like that. If you're going through a will, if you're using a will-centered estate plan, what's going to happen is it's going to be a lot more expensive to run that through probate, because you actually have to then do what's called an ancillary probate in that other state. And which means you got to open another probate. It's a kind of a mini probate. You open that in the other state, and then what happens beyond that is there are certain costs associated with that. So that goes up in cost or raises the cost. You have to hire more attorneys again. But this is the more traditional way to do things. One of the problems too with a will-based estate plan is that it can actually, wills can be challenged. So people, if your heirs are not happy with your decisions, and it could range from everything from where the person who has made the will, they have decided to perhaps disinherit a child or some of their children, or even all of their children. Maybe they're leaving everything to a charity. Maybe they are choosing to divide it up in other ways, feeling like, well, this particular child needs more than the other ones, or perhaps there were certain gifts during their lifetime, and so the parent decides to balance it out, or those kinds of things. And what results is, or what the problem could be with that situation, is that just you can lay these things out, but there are those risks of people claiming that one child or one heir influenced the person who created, the parent, or whoever has created the will, that they've influenced them to leave this other child more money. So then they go in and they can challenge competency and various things that may result in some very difficult discussions for the family, and can really lead to long-lasting animosity and people not speaking for years and years, if not, for the rest of their lives. I've seen it before. It is very sad when those things happen. And most of us, when we're planning out our estate, and if we have children, or even if we don't have children and we're leaving to nieces and nephews, or other heirs, or even to charities, when we're leaving to people, we really don't want to leave that behind us, a free-for-all where people are desirous of challenging it. So, and it's not just the money, it's also just various things. There may be things that have a lot of sentimental value. We don't want to have our heirs getting into a fight over various items or things that we had. We want to be really clear on that. So even if we do put it in the will, that's a good start, but people might challenge it, or there might be problems involved depending on how important those assets are to people.